Insurance policies are contracts, subject to the same rules of interpretation. California's highest court considered whether a public policy-based interpretation of unambiguous policy language was proper in Rosen v. State Farm General Insurance Company. George Rosen owned a home with 2 decks attached. After a contractor warned him that the decks had deteriorated to the point of imminent collapse, Rosen repaired them and submitted a claim to his home insurance company, State Farm General Insurance Company. State Farm ultimately denied the claim, citing the language of Rosen's policy, which covered losses to his home caused by collapse, specifically defined as, quote, actually fallen down or fallen into pieces, unquote. Rosen sued State Farm in California State Court, alleging breach of contract and breach of the covenant of good faith and fair dealing. State Farm moved for summary judgment, maintaining that there was no compensable loss because the decks had never actually collapsed. Rosen countered that sound public policy demanded that his policy be interpreted to cover imminent collapse. The trial court denied State Farm's motion, and the case went to trial on the issue of whether Rosen's policy covered imminent collapse. The trial court ruled for Rosen, citing public policy and observing that restricting coverage to actual collapse would encourage homeowners to delay repairs to guarantee coverage, thereby endangering human lives. The Court of Appeal affirmed, also for public policy reasons, and State Farm appealed to the California Supreme Court.